Hey, beautiful people, welcome back. Have you really asked yourself what law is? Have you truly asked yourself what constitutes what you understand as what law is? And the clear evidence of what law really is? It's very simple. Let's begin with the Constitution that everyone is familiar with. This is how you know what true law is. True laws cannot be repealed. For instance, the Constitution. See these amendments? The first 10 called the Bill of Rights. They have not been repealed, but they created subsequent and additional ones to it after the first 10, which is the Bill of Rights. Again, the first 10 amendments are what's known as the Bill of Rights. It is a body of document and a set of clauses that charges and compels performance. Hence, it holds its own independent title of Bill of Rights. We've went over private right of action, difference between public right, private right, civil rights, and criminal rights in the past. The way you know what real law is when new ones are created. The old ones will not be repealed. When you go into codes and statutes, which are compilations of the actual congressional decisions, whether on a state or a federal level, aka slip laws, aka general laws, aka session laws, aka Congress at large, statute at large, before they're compiled into codes and statute. When you go into those retroactive, after the fact, ex post facto codes and statute, when new ones are created, codes and statute that is, they will repeal it, they will omit it. That's because those are created on a colorable flip side for the specific purpose of doing whatever they want. If it can be easily omitted or repealed, then it is not law. But when newer things are created and it is not omitted, that is how you know it's law. For instance, the preservation of substantive right in Article 4, the right of the people to be secured in a person's houses, papers, or in effect against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. The fifth one, the fifth Bill of Rights, no person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment of indictment of grand jury, except in cases arising in land or naval forces, or in the militia. And by the way, naval forces is admiralty jurisdiction, which is another thing of the loophole of how they can do all these things in admiralty. A lot of people know, well, it's admiralty, blah, blah, blah. They run their mouths about admiralty, but they don't know that exceptions exist, and it's stated in the fifth Bill of Rights. And they are using that against you, but that's another thing. But the preservation of substantive right in Article 4 and Article 5 is reiterated in the 14th Amendment. And that reiteration is this. 14th Amendment, citizenship rights. No state shall make or enforce any law which shall breach the privilege or immunity of any citizens of the United States, nor shall any state deprive any person, here it is right here, deprive any person life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws. This is essentially the basics that's been referred to here in Article 4, 5, basically a conglomerate of the whole Bill of Rights, really. But if they reiterated it in a different manner here, why did they not repeal or omit this? Because this is law. Whenever newer similitude, verbiage, or preservation of rights are similitude, keep in mind I'm using the word similitude now, similitude or preservation of rights, whenever they're created, aka the immunities and privileges mentioned in the 14th Amendment, whenever they're created on the statute level, they will simply omit the old one and replace it. But here we have the Bill of Rights that is still standing and is not omitted, even if the 14th Amendment exists. So that is telling you that laws cannot be repealed because they have the standing. They stand the way they are since the day that they've been ratified. And that is how you have standing when you bring law, because law is the only thing that has standing, because it cannot be omitted or repealed independent of newer appearance, colorable semblance, similitude, supposition, ex post facto version that comes after it. Again, laws, when new similitude are created, do not change. They do not get removed. They do not get superseded. Colorable aspect of it, though, does. That is why when you look at code and statutes, when you look at federal regulations, when you look at federal acquisition regulations, when you look at personnel regulations, or any municipal codes and statutes and rules, they would always omit and repeal things. That is a clear evidence that's letting you know right off the bat that that is not law. And if you're trying to use that as your supposition of claim, you will have no standing. Look into that which, despite newer creations or similitude, it still stands and remains enforceable. Look into that which, if they remove it from existence, it will kill their power. That is how you begin to state a claim, because it gives you standing upon which relief can be granted. Hey, and also don't forget to join my Patreon if you haven't. There I go through documents that I have used personally successfully and videos that I do not post here on YouTube that are in many ways private in nature. And also I go through live audio interactions and video interaction of my own experience with certain things. And I also have a website where you can go through a list of documents or services if you need them. And these videos that are posted on YouTube are also uploaded on Anchor. You can listen to it via audio means. And there's an Instagram page and a Facebook page. The link is on the screen and in the description. Take care and best of luck.